Mr. Nkandla.
Thank you, Chief Justice. Chief Justice, also without waiver of rights, may we proceed to address 4 topics in our oral argument. Firstly, so that you have the scheme of the argument, the issue of exclusive jurisdiction or direct access. Secondly, the question of the status of remedial action directed by the public protector. Thirdly, the simple inquiry, which for us is the heart of the matter: what must the President do? Fourthly, the question of, as it's been put, the conduct of the President. And I won't venture into the conduct of others, but deal briefly with some of the submissions made in that regard, as founding a claim by the EFF and the DA, not merely to the kind of order we propose, but a declaratory order in relation to past conduct. And we want to deal both, first of all, with that notion that when the relief sought, and I could point it out perhaps immediately, if you look at the EFF application, quite rightly, at page at page 9, paragraph 1.2, the President has thus far failed to comply with the report. Our approach is that the President, since November last year, with perhaps incremental clarity, but since November last year, has offered to comply with the report. And to answer my learned friend Mr. Marcus's questions, first and certainly, unequivocally and clearly undertakes to act on the basis of the remedial action which has been stipulated by the public prosecutor. And
just to make sure that you're not in the same position as Ms. Steinbeck. You don't want to be interrupted for 10 minutes. You need protection.
Yes, but may I say it was a cautious partial waiver that if what I say is incomprehensible, Chief Justice, and subject to that. I say meretriciously it may go quicker if I do have the advantage accorded. And the last aspect is the question of costs. So those are the 5 points. On the first point, you would have seen from the letter which we directed to the other parties and to the courts seeking to make plain our position and seeing not if we could settle this case, because that has been the way, unfortunately, it has been portrayed very largely in the media, but in an open and transparent way proposing that which could bring an end to what has been a protracted and very difficult issue which has traumatized the nation in many ways. But the critical thing that we don't want to be seen to be doing in any respect is to obstruct what we in fact are asking for, that you make an order to help this issue be cleaned up. And why I say that is on the issue of direct access and exclusive jurisdiction, we're not raising any bars. In fact, we may be pointing you in a direction which, as I shall show you in a minute, may enable you to, as it were, step around what our learned friend Mr. Trengove rightly conceded. It's the very difficult issue of what exclusive jurisdiction does mean. And we do say that what it clearly doesn't mean is that every time the President is cited, as he so often is in cases, and it entails a contention of a failure on his part to carry out some obligation, which ultimately, of course, if it's statutory, would be rooted in the Constitution, that somebody can put up their hand and say, oh, it's the President, we've got to go straight to the Constitutional Court. So it's a difficult issue. We don't wish to make any submissions in relation to it or direct access. What we would, however, wish to draw to your attention as possibly a helpful way of regarding the situation is that in terms of Section 173, of course, you have the inherent jurisdiction to regulate your own procedures. And there's a judgment of yours in State versus Tunzi where there was a right royal mess by the parties landing up in front of you, and it was not at all clear on whether the court had, as it were, jurisdiction in the formal sense of the word. State versus Tunzi is 2011-3 BCLR 281, and it's paragraph 48. And what the court did is to say, but we've got to deal with a situation where, in that case, there was an order which was no longer good as it stood and needed fixing. And this court exercised its inherent procedural powers to step in and do that. Here we have the public protector having identified, and at least one of the other parties identifying a problem regarding, as in relation to her remedial action, the continued involvement of SAPS. So the question arises, what happens to her remedial action? It stands, it's unreviewed, she really is functus in relation to it. And we would have thought the obvious and cooperative thing for all of us to do is to say, yes, there's a problem there. We take the point that certainly the Minister of Police, and our learned friend reminded us that he is not SAPS, but he stands at the top of SAPS, has in a sense shot his bolt by delivering a report which makes strong, you might call them preemptive findings. And so we would agree with the public protector that there's a problem that has to be addressed. If it has to be addressed, then why shouldn't it be addressed by the parties before you on invitation saying, look, the remedial action stands, we're long past review, nobody wants to go now and try to review, and so what we are asking the court is to catch up, as it were, on time and the passage of time and address that particular problem. And also there's certain issues on timing that I'll come to. So we would then respectfully submit that we say nothing further as regards the jurisdiction of this court. It's in this court's hands. This court, we are suggesting, would, through the way we have pointed, be able to deal with the situation without recourse to the brain damaging exercise of trying to determine the limits of exclusive jurisdiction and when it's in or when it's out. The second aspect, we would also wish to be what the court might think surprisingly brief on, and that is the status of the remedial action of the public protector. Here, there is a continued suspicion that what the President is in some way proposing would have a gap here or entail a duck there. Let me say what I thought had been made clear, and that is that the President accepts that the public protector has directed remedial action in the terms which appear from page 130, I think it is, paragraph 11 of the EFF record. That has not been reviewed. That since it has not been reviewed, it has to be carried out. We submit that in a sense, in this case, particularly because none of us in this court suggests that the SCA judgment in SABC is wrong, does not make it necessary for the court to replow that furrow. It's not a live issue before us if the parties are all agreed that remedial action binds the President and the only way to go is forward, and it must be carried out. But if the court decides that, notwithstanding that, it wishes to deal with that, our submissions from a legal jurisprudential viewpoint on the status of the remedial action is this. We accept that in the present case, what she directed would be administrative action, which would stand and bind unless reviewed. I stress the words "in the present case" because our concern is that one must not glibly equate what the public protector does as always entailing administrative action. She may be asked to look into particular matters where she comes out with an advisory report and she says she's horrified by what she's seen in certain respects, and she would wonder if the Department of Education in Mpumalanga should not look at this or do the other. No suggested teeth at all. And what we're saying is that her powers should be treated as not axiomatically administrative justice, but sui generis. She's an important Chapter 9 institution. Her powers are supple and flexible, and in certain instances she will say, no doubt, this is to happen. I'm told that the public protector in KZN very recently has directed that a building must come down, and there could be nothing more direct and with sharper teeth perhaps than that. That's one end of the spectrum. But all we're saying to the court is that this court has suffered in long years through FedSure, through pharmaceutical manufacturers, through new cliques, about the dangers of saying it's easy. We can always call it administrative action. And in that trilogy of cases, all of them, I think, by the late Chief Justice Chaskelson, the court was concerned to say it's more nuanced, and sometimes the jurisprudential nature may be poised on the cusp between executive and administrative. But I say again, we invite the court to approach this matter on the basis of our acceptance that it is administrative action, it was unreviewed, and therefore, as it stands, it binds.
Just to caution you that it's now open to colleagues to put questions to you whenever they choose to.
I am duly warned. Thank you.
Mr. Nkandla, may I be the first one
Please.
to do that?
Yes.
Since you've actually dealt with the status of the remedial action of the public protector, having regard to the long title of the Public Protectors Act, as well as the preamble, which states very clearly that she has remedial action in the Act, which was amended in 1998 after the 1996 Constitution came into effect. And also Section 6, Section 7, Section 8 of the Act itself. Is the Public Protector Act the national legislation envisaged by Section 182(1), and does it not directly regulate the Public Protector's powers in Section 182(1)(a), B, and C? And I'm aware that the C is not there, but the preamble clearly states to the remedial action that she can take.
Justice Kampepe, the curious thing we would suggest is this. The Public Protector Act is not like PADJA, which was held in New Clicks to cover the field entirely. And if you want to have a fight with PADJA, you must have a fight with the statute and say it's inadequate, there's a gap. What we have, which seems to us slightly anomalous, is that in relation to the Public Protector Act, there seems to be a contemplation, as Justice Kampepe identifies in the preamble, etc., that the Act will actually deal with the remedial action.
Yes.
But then it goes quiet.
Yes.
And the difficulty is then, how are you to deal with that situation? Well, we know that the Constitution has said in 188 that she will be able to take remedial action. It talks about as regulated by national legislation. And the national legislation, on one reading of it, is a little bit short. It really perhaps needed to say not only it does in Section 6, mitigate, etc., but to say even in very wide terms that she could have remedial action. So for us, it's a bit of a statutory curiosity, an underlap, but nobody before you is saying that it's unconstitutional, it's bad.
Yes.
And the solution that we adopt is, on behalf of the President, is to say wherever it comes from, we're going to do this. And I know it's not jurisprudentially satisfactory to the court for us in a way to leap over it, but we say that we accept that the President is required to carry out the remedial action, and for present purposes in terms of pursuant to Section 188, if there is an
You would rely on the Constitution?
182, yes. I would to that extent, but I'm at the receiving end of the power, so it's for others to locate it. But we make no issue of that. May I just pick up one point?
Before you do, just to make sure I understand your position, what, if any, is the fundamental difference between your interpretation of the Public Protector's remedial powers and Mr. Trengrove and Mr. Marcus's?
I don't believe that there is, but I noted when my learned friend Mr. Trengrove spoke, he used a prefatory phrase like it's essentially administrative action. The only thing I've done is to flag that it may not be a one-size-fits-all inquiry, and that if you are to be grappling, despite the SABC judgment, you are going to grapple with the identification of the jurisprudential identification of the public protector's powers. I respectfully submit that it depends on context. If she is, as I say, advising, then it may raise issues as to whether that does bind. Well, I mean, on Padgett it couldn't. It's got no direct or external application.
But one of the powers she has is to make recommendations.
Yes.
If it is something that does not bind, should that be regarded as remedial action or a recommendation? Doesn't it follow that from the powers given to the public protector that you can immediately tell when she sought to take remedial action and when she merely wanted to make a recommendation?
Yes. I would respectfully submit that, again, illustrates the spectrum point that you can have termination of public protector, which are enormously powerful, very strong teeth. They would really bite and bind. But on the other hand, she could be doing something far more nuanced right at the left end. If she makes a recommendation in the middle, it may be a matter for characterization. But I would want to get away from the abstract by saying that we accept it's not just a recommendation. She wanted certain things done, and the undertaking is that those things should be done because they must be done. I know, and our learned friend Mr. Marcus had picked up, there was still a floating recommendation, even in the letter to the court, and that might have been through nostalgia or clerical inconsistency. But our stance is that it's action we must do.
So, does the Act itself not, by way of providing for additional powers, allude to recommendations? The Act itself apparently intended to distinguish remedial action from a mere recommendation?
Yes, we would not fight the fact, as I say, that she can have direct remedial action which goes beyond recommendations. The only point I'm making is that it can be quite nuanced and have a weaker end of the spectrum, in which case there may be no issue of judicial review, and it might just stand as a report. And again, it's analysed in New Clicks when Chief Justice Chaskelson deals with that question of when do you cross the line that it's got enough traction that somebody can't just shrug it off and say it's advice, report, etc.
To make much into, or more than I should, into the submission that you made in relation to the order, for want of a better expression, made by the public protector in this matter. Did I understand you correctly to be submitting that it has to be complied with unless otherwise set aside by a court of law?
That takes me to my third point. The first,
Mr. Nkandla, just on that point, I beg your pardon. Given the submissions that you have just made, then what is the legal effect of the Minister of Police report, if any? Should we attach any significance to that report?
Sorry, to which report, Justice Nkandla?
Minister of Police report, which gave a contradictory findings.
We, as you would have seen, place no reliance on that. There is a sense in which it is raised inter alios acta for present circumstances.
Mr. Nkandla, just to make a...
I'm sorry. Yeah, thank you.
If my sister is through, my sister? Mr. Nkandla, just to make a follow-up on what the Chief Justice put to you, is your submission in this matter that the remedial action that was taken by the public prosecutor, that it was by the public protector, was binding and therefore had to be complied with?
Yes.
To take it further on that point, So the next step, the step that has to be taken, is to actually quantify the reasonable cost as instructed by the public protector.
Exactly, with respect, Justice Nkandla, and I would like to come to that point, but I see the Chief Justice is going to stop me.
Yeah. What is it that has been asked for that you disagree with?
Now, I'll tell you what it is. It is we make a proposal in November. We say that a problem has been raised in relation to SAPs, and we ourselves would accept that there is a problem of, well, at least of perception. So what about putting in the Auditor General together then with National Treasury? The Public Protector doesn't like that. The Public Protector would rather than just cut out SAPs and just have the National Treasury doing the quantification exercise. That is the one point. But the other point, which I must deal with in a moment, is the lurking flirtation which bubbles up every now and then through our colleagues' arguments, that this quantification process, which by the Public Protector's contemplation was to be done within 14 days, and in the notice of motion of the one party 14 days or 30 days, would open up again the inquiry of whether, apart from the 5 items, other items are non-security. And what we say is, no. Arduously, she sifted through everything, true her report in parts, and with great respect, there's some looseness of drafting, but she ultimately ended up in the conclusion of saying that of 5 items, I put one side of a line, and in relation to that, the double compensation process must be established of a reasonable proportion of a reasonable cost. And that is where we differ. And might I, in that regard, just hand up the single page of the order which we prepared, which is based on what we'd prepared before, but which seeks to accommodate certain other tweaks, and I won't say where they come from, but in relation to this.
Fair to assume that your learned friends have had sight of it?
Yes, they had it yesterday, and as I say, it only tweaks slightly, and I'll identify what it is. Paragraph 1 is...
Not there yet.
I'm sorry, I apologize, Chief Justice.
Thank you very much. You may proceed, Mr. Nkandla. Thank you.
Thank you, Chief Justice. Paragraph 1 is a copy of, if you go to the EFF record at page 130 of her paragraph 11, with one change, and that is we used the words where she had in the third line, at his private residence, we said at the Nkandla homestead, which we thought was more appropriate, but if anybody wishes not to consider it that way, then so be it. And then 2 is, I would have thought, unexceptional. 3 was proposing that in a way we put ourselves under the supervision, if you like, of this court, as had been contemplated, that National Treasury reports back. 4, the President is to pay that amount within a time afterwards. 5, there'd been some to and fro about, because both those cabinet ministers had been removed from their posts, or put into one removed entirely from cabinet and one put elsewhere. But we accept, and the President will reprimand. There's no difficulty about that. And then there was a point about costs, which I'll deal with at the end.
3, this period, the 90-day period, is it open to discussion?
Oh, absolutely.
I say, mindful of the proposal by the EFF that, let the work be done by Treasury. I don't know whether they had any objection to the Auditor General, but be that as it may, within a period of 60 days? Or is that what appears in 4? No.
For paying is faster than finding out or dealing with the process. So we thought it was realistic.
So you stick to 90, you're not accommodating 60, or is it open to discussion, you're saying?
We're not here to dictate, Chief Justice. It's what we would suggest that it's a realistic assessment, and this court has bitter experience of over-optimistic litigants.
Yes, that I understand. It's a draft order, but I'm just trying to narrow down the issues.
Yes.
So that even when Mr. Trengrove makes a submission,
Yes.
He would know already whether the 90-day period proposed here might be changed. Whether he needs to address this issue or not.
Absolutely. I mean, it's been, as I say, the subject over 10 days of our to and fro of correspondence.
And the 60 days?
And the 60 days
to pay
is a proposal of 60 days to pay.
They seem to be suggesting 30. I got a sense that they were suggesting 30 days. Is that feasible? Or are they asking for too much?
I have no submissions other than that what's put up is eminently reasonable, practicable and if it's demonstrated that it should be 32 days or 81, we are or so found by the court, then so be it.
Mr. Nkandla, I note that the draft order does not have what you have just conceded to, that the remedial action are binding. That seems to be the only thing that worries me in this order.
What you have is a dispute between parties. They want remedial action against us, and what we're trying to do is replicate page 130. That doesn't require or contain anything in about our acceptance that it's binding. This does. By tendering an order which says, please do this, it's accepting that it's binding.
Mr. Gauntlet, the EFF has maintained all along that it's doing this as a matter of principle, and that therefore it wants the court to determine the legal status of the public protector's orders.
Yes. Well, then, Justice Cameron, it takes us back to how the court, if the court wanted to add something regarding that it is binding when it is going to bind through the order, but regarding the status, we just make the point that the court would obviously be concerned to say that this remedial action was binding, because we're just saying that there may be other remedial action which she makes in other contexts which is not binding. We weren't trying to exclude anything, we were just trying to deal with this case and accept, as I say, that the action must be carried out. Now, what then remains? What then remains is the attempt.
You've said it 3 times, Mr. Nkandla. What remains?
I'm sure you wanted our attention.
I'm saying this just to apologize. We're having a little judicial chat here.
I see.
Yeah, very well.
Yes. What then remains, Deputy Chief Justice, is that we must deal with the contention that the conduct of the President is such as to make additionally necessary to what the EFF and the DA press for, which are declaratory orders which go beyond what Justice Cameron has put to me as is it now common cause that the order binds, and we say implicitly through the order, but if one wants to put it in, it can go in, but something much more. And what that is premised on what was ambitiously first termed the defiant conduct by the President, and which very properly and appropriately our learned friend for the EFF in the end accepted that, first of all, there was no suggestion that it was other than bona fide. It was, in fact, nothing other than a mistake of law. Our learned friend for the DA was very unhappy with this concession and sought to instill new vigor into the point by arguing for some turpitude on the part of the President in this regard. And our submission is this, that until such time as the SCA had dealt with the matter, there was a judgment, a High Court judgment, which founded an approach different to the one I've articulated. And just as it may have been that judge was wrong, so it may have been that others were right in considering, well, this is the current state of the law. Until such time as the SCA rules upon it, this is how we must answer and put out our papers. There's nothing turpitudinous about that. The suggestion, and the court will be mindful why there is this enthusiasm for more orders. This is a delicate time in a dangerous year, societally, and the concern that we have is that if at any time it is thought by either of the official opposition or the EFF that they wish to bring impeachment proceedings, they have, of course, that right. And they may do so at any time, as they have done in the past. But what would be wrong would be for this court to be inveigled into a position of making some form of wide condemnatory order which would be used effectively for provisional sentence for an impeachment in Parliament. To say that this court has said that the President violated, failed, when what one has to face is really this question: why those declaratory orders? What is the utility of them? I still know no better dealing with declaratory orders in our law than Professor Baxter's dealing at pages 704 to 710 of his great book on administrative law. The critical thing, the court says, I don't give advisory opinions. I'm not here simply to declare things. Least of all am I here to be drawn into future or past conflicts. You have a situation which no longer prevails. If since November, or whether it's since last week, the position is that it is accepted that the order binds, then there is, with respect, unless you did have our learned friends saying, look at this, the President was clearly in bad faith, was clearly up to no good when he did this. You simply have a situation where the high water mark of the argument is that Judge Skippers was wrong, the SCA is right, and when the President was effectively through the papers following the line in the Western Cape, that's now wrong. Well, we all do that. So we would respectfully submit that on the jurisprudential level, declaratory orders do not get given when there is no utility for them. They do not get given ordinarily for historical reasons. They must have a utility which reaches into the future, which shows why they're there. And thirdly, on the factual level, once our learned friend for the EFF quite correctly conceded that there could be no argument of bad faith or misconduct by the President in that sense, then the attempt by the DA to row back on it was significant. There is no factual basis, and that in those circumstances, we say that the order which should properly be made is along the lines which we were suggesting in November and have, since everybody's heads have come in, sought to polish and put into an order form. So we would respectfully then submit that if you want to have a picture of how the parties stack up, they stack up in this way. As regards this question of whether the order the Public Protector's determination for remedial action, whether it is related to 5 non-security items and to the quantification process in relation to the 5 non-security items, we say this, that she thought it could be done in 14 days. That is the argument for the EFF and the interpretation of the last paragraph of 11.1.4. The DA, we heard in argument, doesn't accept and says, no, in this quantification process, as they go along, they can now decide, no, part of the roof is in fact a luxury item or whatever has been exonerated, e.g. the tuck shop. She took out of the mix and said, no, she's not putting it into the personal expenditure thing because it had to be moved as a consequence of the security building and the like. We say it's not what she ordered on a plain reading of it, on the sensible aspect of the time which would be required to do it, nor is it the pleaded case of our opponents. The EFF at page 16, paragraph 27, accepts that it's the 5. The DA, we had quoted to us the DA founding affidavit. The DA replying affidavit at page 1207 to 1208, paragraphs 30 to 31, accepts in terms that it is just the 5. So as regards the dispute, the list between us, it is the 5. And we would have thought that our order certainly, may we say, would be unworkable on the time we talk about. If this poor National Treasury official has got to go and do what has been done through a whole process of architects and inputs of reports, but he or she has to go and do effectively a reappraisal in relation to the project. Then we're talking about a year's timeline, and we would in any event suggest that the public protector's own hair would stand on end at the thought that what she'd struggled through was to be redone. And in fact, it's very inconsistent with her own stout-hearted defense of her jurisdiction. I've done it, here's the remedial action, I can't count it up, now go and count.
Please help me understand this, because I would want Mr. Trengrove to also assist me when it's his turn. Is it open to Treasury to come back and say, I haven't been able to determine any non-security feature properly so-called beyond the 5 specifically identified by the public protector, or would that official have acted contrary to what the public protector's remedial action requires of him or her to do?
Yes. Our answer would be, as you read page 130 and ask the Chief Justice's question while one's reading it, how could it be that the public protector would consider that the President is to take steps to determine the reasonable costs and the reasonable percentage of the costs while not knowing of what? Because the way the public protector has done it, she's gone through the whole catastrophe. She's said that the 5 items, which I put on one side, they can be quantified. But if while you're supposed to be quantifying them, you're supposed to be establishing whether more go across to them, it's conceptually very difficult, and it's certainly not what a report says, or a recommendation says.
Well, and I'm only seeking clarity so that I know exactly where you stand. You see, there is room for this argument, I think. There seems to be room for argument to the effect that the public protector believed that her list is not exhaustive. And it is for this reason that she mentioned SABC, or the Minister of Police, I don't remember anymore, as one of the people to look into the matter together with Treasury. Yes. So that with the benefit of expertise in that department in relation to security measures, they would then be able to identify additional non-security measures that she might have overlooked. Yes. That's where the including comes in. So once they have done that, then the determination not only of the 5, of the reasonable cost, not only of the 5, but such additional non-security features that might have been identified by these 2 would then follow.
Yes.
So they may pick them up, they may not pick them up, I don't know. That's why I need to be assisted by you.
If I may, on that point, Chief Justice, first of all, the word including in her remedial action at page 130, including we know is a weasel word often in statutes, because depending on the context, it may mean when it says something, comma, including, and there's a list, it means. Sometimes the doubt is taken away by a last phrase which says, and any other such matters, or something of that kind. You would have to interpret this not as a statute, but contextually. And our learned friend, Mr. Trengrove, took you, and quite rightly, to 2 passages to which I'd like to revert. One at page 118 in the EFF report, and this is to called in aid of the more expansive interpretation that the Chief Justice was debating.
118, I didn't write.
Yeah, 118, para 10.3.2. And if I might ask the court to look at it, it says measures that should never have been implemented as they are neither provided for in the regulatory instruments, etc., nor reasonable, comma, as the most cost-effective to meet incidental security needs. And the trouble, with due respect, with some of this drafting is that two things are run together. One is a sort of a vires point that they're outside, they shouldn't be there because, like ping pong tables, it's not on the list. The other is that it's nor reasonable as the most cost-effective to meet incidental security needs, which seems to go into that it's expensive for what you get. And then comes the list, including the visitor center, the cattle kraal, the chicken run, etc., some of the paving, and the relocation of neighbors who used to form part of the original homestead at an enormous cost to the state. But I don't know what we're supposed to do about the relocation of the neighbors. It's happened. It's not one of the items, but this one long sentence puts together a mishmash of considerations, which in the end the public protector says, I don't find this really good, as we understand it, public expenditure. And then the next passage our learned friend took you to is clearer, and this may help, Chief Justice, at page 126, para 10915, the last para.
Para?
10915. It is also my considered view that the amount in question, this is to be repaid, should be based on the cost of the installation of some or all the items that can't be conscionably accepted as security measures. Conscionably, I, with respect, don't understand, but they can't be accepted as security measures, and then follows the usual list of the five. And she goes on, the President and his legal advisors did not dispute this in their response to the provisional report. And the President didn't dispute that during the investigation that he told me that he requested the building of a larger kraal and that he was willing to reimburse the state for the cost thereof. Now that's the last bit of report narrative, and from there you go to page 130. We can only say that what the public protector was doing was exactly what an ombud or person in an ombud's position should do. It's what is sometimes called quick and dirty, not in a pejorative way, just meaning it brings an end, brings finality and clarity. And what she was saying is that what I think really don't fall the one side of the line are the five. And that now must go and be quantified. What she could not have been thinking of doing, least of all in 14 days, is that this poor wandering National Treasury official goes around in Nkandla forming different views and saying that there are other items which are to be moved over onto that side of the line. That's our predicament, and that's the argument. So,
round up that point, I need to ask another question.
I think I finished this.
All right. Now, I don't know. I've seen a few things around here. I would go to the shop, buy something for 10 rand or 20 rand, but once the state tenders, it could easily cost anything between 50 rand and 100 rand because the state is involved. Now, in this exercise of determining reasonable costs, I'm sure, is it fair to assume that it is not the actual cost, the actual amount that was expended, it is what should reasonably have been expended for that item, not the state kind of pricing?
The Chief Justice is, with great respect, exactly right, and it's coupled with another consideration. What she was wrestling with, and we'll find the passage for you where she says, he needed at Nkandla, I've been practicing to say it with a very short A before I get criticized, but what she says is that he needed water, a water reservoir for security, whether it's for fire or whatever other use. You've got to have water there. And she deals with the question of the pool on the basis, as far as we can see in the report, of you take away, effectively, the cost of a reservoir from the cost of a pool. It's complicated by the fact that she is finding throughout that all this was done as the Chief Justice moots, not on a reasonable basis. The picture of fleecing by contractors and others is very, very clear from this report, and there are continuing, as you know, investigations and disciplinary and other proceedings and an SIU matter, civil recovery matter. Bottom line is what she was doing was to say you've got to get a reasonable proportion of the reasonable cost. So if a reasonable cost of a swimming pool at Nkandla is 40,000, 50,000, I think it is in fact on the papers 240,000 rand, then a reasonable...
Is that what is reasonable or what it costs?
No, I think it cost 2.6 million. I think that's, as I recall, yes, that's the problem. That's the problem. So the public protector is saying the reasonable cost she's established through the DPW estimates is 240,000. And then the question is, what is a reasonable proportion? Well, that may well be to say, well, we've got to give him the benefit of the fact that whether or not whatever public merriment may have been caused by the swimming pool, there needs to be a water facility which can be used at times. And the bottom line is she's saying, that's the way we do it. It's one of the suspect items. It's a reasonable proportion of the reasonable cost. And she says reasonable cost because she knows that this has been a rip-off operation in relation to the way it was built by those who were supposed to be doing it under DPW tutelage. Have we found the reservoir?
I think that's that one.
There's the reservoir point. I know there's another passage I have in mind, but it's at page 212 in the Democratic Alliance papers, paragraph 720.4. But
Mr. Nkandla, while you're there and you take your breather, you're not inviting us, are you, to go and make an order that contemplates setting up those parameters for National Treasury, are you?
Not at all. Not at all, but what I am saying...
And secondly, you're not inviting us to make an order that is open to some Audi alteram partem of sorts. Once we make the order is binding, the numbers that come back ought to be paid within the times that are set out in the order. Is that your invitation to us, or is it something different?
The invitation is as in terms of the order, which makes no provision for any kind of interlocutory Audi or anything else. The official would do as she says. But, so I'm certainly not going there. My concern is that that official is bound, as we all are, by what the public protector has ordered here, for good or for bad. Because one thing that has come out of this litigation is that certainly her remedial action could have been a lot more clearly framed, and it has been problematical, which also goes back to the question of when people like the President...
No, but how do we convey that to National Treasury? That's my point. Are you inviting us to make set out some principles that will tell National Treasury how to calculate what is due? And hence my next question. Once we've determined what is due, is it open to us to enter into some other process?
Not at all.
So what's the benefit of all this?
The benefit of all this, it has been argued or suggested, the public protector's award for better or good is as it stands, that it does not have the meaning that the quantification is to be carried out in relation to the five, as it were, what she called the non-security items. That official, I'm arguing the converse to what the Deputy Chief Justice is putting to me, that official is going to be, on the approach it's suggested, required, set at large, to wander around in Nkandla and to perform the exercise again as from day one. And that, we're saying, is not what she meant, couldn't have meant. We're saying, for better or for worse, we're all stuck with the order and the process, and I think many of us would wish good luck to the Treasury official in carrying it out.
Tell me, is it necessary for any report back to be made to this court, or do we just make our order and it's over and done with?
We ourselves don't see the need for that. The others have argued for it, and I think this court has seen that sometimes it is unduly burdened with structural interdicts in inappropriate cases, but we don't argue for it, Chief Justice. Yes.
And in principle, you're not opposed to that. That's why it's in your draft order.
Not at all.
Okay.
Not at all. Chief Justice, I promised the reference about the difference in costs between the swimming pool and the reservoir, and that is at page 175 of the DA papers, para 6.72.13, and that same logic applies to the amphitheatre, so-called, at paragraph 6.64.12. And if one reads the report in that way, that's what she's doing. She identified the problematical areas, and she was thinking what's got to be established is that kind of gap, reasonable proportion of reasonable cost because of the builders who've ripped off everybody. I was giving you a little summary in conclusion of where we understand the parties to be. So we understood the DA and the EFF to have pleaded themselves into an acceptance of the 5 items. I gave you the references where in the affidavits they say it's 5. We see a rowing away from that in the course of oral argument. The public protector, as we understand it, asserts that it's not just the 5, it can be any of the others in this process be brought back into account. And we say for the reasons I've argued and won't repeat, it's wrong. Secondly, the public protector and the EFF accept the need to substitute SAPs. And we've accepted that too and said, well, if there's a difficulty because the minister is seen to have shot his bolt and he's going to have police officials who work under him, and it's invidious to have the Minister of Police doing the exercise, then so be it. But, Chief Justice, if you wish to, with respect to, as it were, to photocopy or keep what the Public Protector has said in that regard, in spite of what she also indicates, she only wants Treasury. She doesn't want any other help from Auditor General, which we suggested just to make this process even more transparent. We would go along with that. Fourthly, the EFF and the Public Protector both accept that the President has acted by mistake of law, bona fide, or conversely, that apart from what our learned friend said delphically, that one has one's suspicions, he could not say anything to the contrary, our learned friend Mr. Trengove. What there was is, in a phrase used by at least 2 of my colleagues, an evolution of thinking. And that evolution of thinking is unsurprising given the fact that this is new territory. The powers of the Ombud have not been tested as they have been prior to the SABC case. The case was approached at the time on the basis of the judgment of the Western Cape High Court, and so viewed there is no reason for these suggestions the DA persists in still of willful defiance. And we say for those reasons there should be no other declaratory orders. The order should be made. We should get on and finish this process. Lastly, on costs.
Before you walk away from there, you rather quickly, when you asked about the report of the Minister and the report of the ad hoc committee,
yes,
what should we do with that?
We would respectfully submit nothing. The point about it is we're here on the question of what we should do with the Public Protector's remedial action, its status, and how it should be implemented. And we say that the heat and the dust which has taken place peripherally, once it's accepted, as it must be, unless one goes the DA way of saying the President's the top of the pile, therefore in a way we didn't quite follow, he is responsible for everything the National Assembly did, plus the Minister of Police.
Bare minimum, are we required to say that they have no legal significance in the light of the holding about the powers of the Public Protector?
I would respectfully submit that there's a parity of reasoning with the SABC case to say that, as was said in that case by the SCA, if you want to have parallel processes, Section 13 of the Public Protector Act as Justice Cameron drew our attention to very carefully, says this doesn't stop ministers doing what they think they should do or can do, but it's not part of that, and it can't trench upon the public protector. That's all that it would be, just like the SCA said, have your reports to your heart's content, but do
may any of them second guess the public protector's order?
Yes, well, that's exactly what the SCA was saying.
May or may they not? I'm sorry, what's your answer?
Certainly not.
Do you say they may not second guess the...
Certainly not, Deputy Chief Justice. Certainly not. And on costs, our submission is simply that if you hold BioWatch applicable, then we would say that any costs such as you may give should be limited as you would, with respect, ordinarily do to the costs of two counsel, where two counsel were engaged. The plenitude of counsel on our ranks might have something to do with the fact that we've had 5 concurrent legal proceedings to deal with in this matter, a number of parties in court, and other entities who, while they may be amici, were no amici of ours. Thank you, Chief.
If you're offering costs for two, in the case, for instance, of the EFF, is it for 2 senior counsel, or how do you want to ration it out?
We would simply say 2 counsel, Chief Justice, and I'm sure strictly on merit they would decide how to apportion those costs.
Mr. Gauntlett, just explain paragraph 6 in this document you handed up. What costs are those?
This was the proposal which was made in the draft order. It's one way of approaching the costs if you were to have a structural interdict and you were going to see the outcome. But I've dealt with it already on the basis that you may wish to approach it as costs related to this application, these proceedings and hearings. But we leave costs in the court's hands. Thank you, Chief Justice.
Well, thank you for donating 15 minutes to us. Thank you very much, Mr. Nkandla. You've been very helpful. Ms. Nkosi Thomas.
Yes, Chief Justice, may we ask for your indulgence for 5 minutes? We've got to do a shuffle to enable...
5 minutes. I think 2 minutes is fine.
We'll be fast.
Thank you.
You're watching SABC News. It's just gone 1500 hours Central African time. What you're seeing now is live visuals from the Constitutional Court in Bromfontein in Johannesburg. Now, this much anticipated hearing to the powers of the Public Protector, well, that got underway this morning. We've just had a 5-minute recess. Let's listen in.
A measure of joy in my heart, and I'm sure I speak on behalf of colleagues, that one of our former clerks, your junior, Mr. Musandiwa, is appearing. We get encouraged because it does seem to suggest that we're doing well to groom them.
Thank you, Chief Justice, Justices of the Court. We propose the following structure to structure our argument in the following manner before you this afternoon. Firstly, we propose to deal with the powers of the National Assembly in relation to the report of the Public Protector. In other words, those powers of oversight and accountability, their source, and whether or not they were complied with. That's the first issue that we propose to deal with. Secondly, Justices, we propose to respond to the various contentions or rather submissions made by our learned friends for the EFF, the DA, and the Public Protector. We will then deal with the issue of direct access, condonation, and costs. The complaint that is before you this afternoon, insofar as the National Assembly is concerned, is that the National Assembly has defied the Public Protector. The National Assembly has been said to have arrogated to itself powers of review and sought to second-guess the Public Protector. And as one read the papers, and I propose to deal with both applications, the DA application and the EFF application, because essentially the issues, they are similar, although not identical. EFF relies on the specific provisions of the Constitution, and they point this court to the provisions of Section 55, subsection 2. The EFF proceeds to rely on Section 181(3) of the Constitution. What those two sections provide for justices, much has been said about them, and I'll be brief. Section 55(2) of the Constitution enjoins the National Assembly to determine mechanisms of oversight and accountability. Section 181(3), on the other hand, enjoins, I beg your pardon, Chief Justice? We didn't actually get a lunch break, so. Thank you. Section 181(3), on the other hand, enjoins organs of state to assist the Public Protector in the discharge of its function to promote independence and those values, effectiveness, those values set out in the section. Now, the question is, what therefore is the National Assembly's role in all of this? What you have not been told throughout today is that the actual source of the powers of the National Assembly is Section 42, subsection 3 of the Constitution. And we propose, Justices, to take you directly to that section. What 42(3) says is that the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. That subsection goes on to tell us exactly how the National Assembly is to perform that function of representing and ensuring governance by the people. It says, it does this by choosing the president, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. That is the source of the power we submit, that the National Assembly invoked, the section that was invoked, that was set in motion when the President reported to the National Assembly. What Section 55(2) does, Justices of the Court, is to enable and or empower, as it were, the National Assembly to set up procedures, mechanisms to exercise the 42(3) power. Now, that we propose should be the starting point in the debate around whether or not the National Assembly acted appropriately, not appropriately, derogated to its self-powers it did not have, second-guessed, and so on and so forth. The question is, can it be said on the conspectus of all the evidence before you that what the National Assembly did amounted, at the end of the day, to an exercise in scrutiny with a view to exercise oversight, and of course, eventually, with a view to holding the President to account, and as Justice, I think it was Justice Madlanga, I beg your pardon, Justice, who raised the issue, no, it was actually Justice Jafta who raised the issue about around Section 89 as a mechanism of holding the President to account in circumstances where certain breaches have occurred. So the process first is to scrutinize, we submit, and oversight, and then hold to account. That's how we propose the role of the National Assembly, and rather the evaluation of its actions in this matter are to be evaluated within that context. Now, having stated that, perhaps one should now go to the remedial action, and I'm going to try and be brief before I forfeit my
Before you move on, Ms. Nkosi Thomas.
Am I outside of my 10 minutes, if I may inquire? It's just an inquiry, Justice. Well, I needed to find it in the papers, but Justice Madlanga, please put your question.
No, you are still within the 10 minutes, I understand. Huh? Yeah.
May I proceed, Chief Justice?
Yes, you're left with 3 minutes before your 10 minutes is over.
The remedial action that was directed by the public protector. In this regard, it's important in our submission to highlight that she does not order the National Assembly to do anything. That's the first point of departure. What she does, however, is to direct the President to do certain things. She does not say, I've made the point. So how the National Assembly gets embroiled in this matter is through the invocation of paragraph 11.1.4 of the report. And there, she says, the President is to report to the National Assembly on his comments and actions on this report within 14 days. She stops there. She doesn't tell the National Assembly what to do upon receipt of the report. Now, at that point, we submit, Justices, when the report finds its way to the National Assembly, the Section 42(3) powers of the National Assembly kicked in. And the process that unfolded from then on is, with respect, to be viewed in that context. Just dealing with the facts briefly, going back to the chronology, on the facts, it's very clear that on the 12th of April 2014, the President wrote a letter to the National Assembly, and that was within the 14-day period of paragraph 11.1.4. He was 2 April, I beg your pardon, Justices. In so doing, the President was heeding the conjunction of the public protector. The exact source of that reporting mechanism, Justices, is to be found in the Ethics Act. I'm not going to take the justices there, but the manner of reporting by the public protector accords entirely with the scheme of the Ethics Act. So the Ethics Act as well, the Executive Members Ethics Act as well. In brief, enjoins the public protector to conduct an investigation where a complaint such as here has been made by a member of Parliament, remembering that the former member of the DA, Ms. Mazibuko, is the one, among other people, that lodged a complaint. So she lodged a complaint to the public protector in terms of the Executive Members Ethics Act, alleging a breach of the Code of Ethics.
Well, your 10 minutes is up now. Let me just try to understand the National Assembly's position. Does the National Assembly accept as correct the meaning given to the public protector's remedial action, to the benefit of all the written submissions and oral submissions in court, as articulated by those who came before you?
Chief Justice, it's not necessary to deal with that question insofar as the actions of the National Assembly are concerned in this.
So
in order to determine whether the National Assembly has acted properly or not, it's not necessary to deal with whether the powers are binding or not, because firstly, the public protector did not direct the National Assembly to do anything. So the question of whether or not the Assembly was bound by this report does not arise on the facts of this case. That's the first thing. But the second submission that we wish to make in that regard is that the powers of Parliament, such as they are such that they cannot be fettered by any Chapter 9 institution, and that institution with respect includes the public protector with respect. And when the President reported in terms of the Ethics Act, the general powers of the Assembly of oversight and accountability and scrutiny arose. And that's hence, it's not necessary for us to determine that. That issue is not determinative of how our client has gone about.
When the report of the public protector was received by Parliament and the report by the President was received by the National Assembly, what is it that the National Assembly was, in terms of the Constitution, required to do?
Yes.
You see, we need to find out first, what is it that it was required to do, and did it do what was required of it?
What the National Assembly was required to do, Chief Justice, was to scrutinize the executive action that was at the center of the report. It is the executive action that the National Assembly has oversight powers over.
Within the context of the findings of the public protector and the remedial action taken.
The public protector, what the public protector did, took remedial action against the President, not against the National Assembly.
No, that is a common cause, I think.
Having done so, he said, you report yourself to your master in terms of the Ethics Act, because you must account to your master, who is the National Assembly, with your comments and the actions taken. And, which is what the President did, that on the 2nd of April,
what then are the obligations that rest upon the National Assembly which ought to have been carried out? What is it that the Constitution then required of the National Assembly to do?
Indeed. What the Constitution, at the risk of repeating myself, what the Constitution required of the National Assembly to do when one of its own reports to say, I have allegedly breached the Code of Ethics. It then says, in terms of 42.3, scrutinize this executive action that is the subject matter of this report and exercise oversight over it. And indeed, hold the President to account, Section 80, Justice Jafta's point. But it's impossible. A suggestion, maybe I shouldn't go there because now I'm going ahead of myself. So now, back to the Chief Justice's question. National Assembly tells itself, now I am enjoined to scrutinize this executive action in the name of the Nkandla upgrade.
Let me try and narrow it down. Here's the Public Protector's report. She says, you know what? We've investigated and I'm satisfied as the Public Protector that in the course of the construction that was taking place at the President's residence, there are features that have been identified as non-security features that have been built. And the recommendations then, this is what the President is required to do. The President then gives the National Assembly a report. Wasn't the responsibility of the National Assembly to then hold the President accountable based on the findings and the remedial action taken by the Public Protector, as opposed to conducting an investigation that is designed to show that the Public Protector is wrong? That's really what I want to know.
No. Chief Justice, what action the National Assembly was to take after the scrutinizing the decision, it's not something that could be, in other words, it cannot be a rubber stamping. So the National Assembly was obliged to scrutinize that action. And what does scrutinizing mean? So it could have eventually enforced, but it's not a question of enforcing without more. Well, because then you're dealing with a fettering, you're dealing with a dictation, you're dealing with abdication. And that can never be the scheme.
I'm sure you have forgiven me in advance for interrupting you in the manner that I do. I'm only trying to understand the submissions of the National Assembly. Look, the Public Protector takes remedial action.
Yes.
And I'm sure you're as familiar with the decision of this court in Kurland as I am. Are your learned friends who made submissions to the effect, including Mr. Gauntlet, to the effect that for as long as the remedial action taken by the Public Protector in terms of her constitutionally conferred powers remained unchanged, in other words, for as long as they were not set aside by a court of law, the responsibility of bodies like the National Assembly was to hold the executive accountable by ensuring that they are implemented? No. What's wrong with that?
What is wrong with that, Chief Justice, is that it confers a power to the Public Protector that she does not have. She cannot direct Parliament on how it should conduct its affairs.
All right, let's take it in stages.
She cannot dictate to Parliament and say, Parliament, get him to pay, otherwise invoke 89(1), for example. Right. That she cannot do.
Is it open to the Public Protector in the exercise of her constitutional powers to say, we are satisfied that these are non-security features and apportion for their construction must be paid by the President. Is it open to her to say that and expect of Parliament in the exercise of its obligation to hold the executive accountable to facilitate the implementation of her order or decision?
Our submission to this question that the Chief Justice is putting to us is that Parliament had to apply its mind to the executive action. That was the subject of the report.
Let me put my question differently.
To do otherwise.
As part of scrutinizing and so on, is it open, or was it open to the National Assembly to set aside the remedial action taken by the public protector or to nullify, render of no force and effect the remedial action taken by the public protector? The gauntlet says, no. For as long as that hasn't been set aside by a court of law, that remedial action had to be carried out. It had to be implemented.
It is binding.
You say he's incorrect.
No, and we don't have to say he is incorrect, because he is saying, as I understood his submission, that it remains binding towards the President being the person who has been directed to do certain things. Ours is a different function. Ours is not an enforcement. We're not the sheriff. Ours is not an enforcement mechanism or similar, akin to the sheriff of a court, where we would... Her remedy lies elsewhere. She might just want to approach the court and get a mandamus, but she cannot look to Parliament and expect of Parliament to merely rubber stamp without applying its mind, because Parliament would be acting too eagerly to enforce. So the role of Parliament is different, and
right.
that's our emphasis.
My last question, and I know I'm repeating myself. So, it was open to Parliament to effectively render, after investigation, after scrutiny, to effectively render the remedial action taken by the public protector in terms of Section 182 of the Constitution of no force and effect.
No.
By investigating and arriving at the conclusion that no, we don't agree with her. Our conclusion is the President is not to be held liable. We even disagree with the President. He shouldn't be held accountable.
The first point, perhaps, that we should try and emphasize is that at no stage did the National Assembly seek to nullify. That administrative action is still there, and whoever has rights and obligations in terms thereof, nothing stops them from honoring those obligations.
Ms. Nkosi, when you are finished with your point.
The converse is the following: is to interpret 181.3, the word assist, as conferring powers of dictation, really, to Parliament. Now, in the spirit of interpreting 42.3 and 181.3 harmoniously and consistently with each other, that interpretation would then, you can't scrutinize on the one hand and rubber stamp on the other. So what that interpretation, the interpretation that is being sponsored, leads to, it leads to two provisions of the Constitution being in conflict with each other.
Let me interrupt you, Mrs. Ngosta. That scrutiny relates to, does it not, what the executive has done.
Yes.
Say the minister is supposed to spend a budget on building schools or whatever, and come time to account, that hasn't been done. You scrutinize that which that ministry, that department has been doing over the financial year and say, come, we've looked at what you've been doing. What about this? What about, not to scrutinize the power, the exercise of the powers of the public protector as in this instance, is it?
But that's not.
She's not part of the executive. I thought the section you referred to talks about scrutinizing executive action.
I'm going to retrace and perhaps try to summarize our argument and move to the other issues perhaps that we wish to canvass during our argument. How the matter came before the National Assembly was through the President reporting the executive action, namely Nkandla. And that is what they were. It's not a question of the public protector having submitted his report to Parliament in terms of one of the sections where it says that where it requires the intervention. In Section 6, it says where the public protector is of the view that any matter he's finding requires the intervention of Parliament, then she would submit to Parliament and say, help me intervene, help me enforce. That's not what this case is about.
But the National Assembly could not close its eyes to the public protector's report. It was aware that the report or whatever it was by the President was in relation to or in respect of the public protector's report. So this goes back to the question that the Chief Justice has been asking you throughout. But anyway, let me just take the point forward a bit. Throughout, if I understood your argument correctly, your context seemed to be Section 89 of the Constitution. Are you suggesting that when the National Assembly was engaging in what you called scrutinization in the context of Section 89, which is about the removal of the President, that the National Assembly was considering whether or not to remove the President?
No.
And then if that is your point, is there any objective material before us that shows that that is what the President was about?
Thank you.
If that is not the point that you are making, why then in this context do you keep referring to Section 89?
Yes. That's not our submission. The submission is that the process is firstly that the impugned executive action must be scrutinized. And when Parliament is satisfied that it exhibits a breach of a constitutional obligation, a breach of the code of ethics, a breach of whatever type, then only then would it proceed and impose whatever sanctions it has at its disposal. That's the analysis. So it's not a question that an outsider to Parliament could come and say, Parliament, go and remove. That we submit, that can never be the correct construction of the constitutional provisions. So this is hence we argue that the correct starting point is first when the executive action is drawn to the attention of Parliament. Parliament has to apply its mind to it. Even the report of the public protector, read with the provisions of the Ethics Act, it says report together with your comments and actions. It can hardly be suggested that all that Parliament was to do was to disabuse its mind of the comments, disabuse its mind of the actions, and merely focus on what. So what had to happen is that the National Assembly had to scrutinize, taking into account a whole conspectus of evidence that's before it that has a bearing on the impugned executive action. And then once it is satisfied, only then can issues of enforcement, issues of removal, issues of whatever arise. To look at it differently would suggest, in our respectful submission, a dictation. And it would have the effect of tipping the provisions of 181.3, that word assist in there. Assist, if assist is to be interpreted to mean rubber stamp, rubber stamping and scrutiny, those kinds that two mutually exclusive.
The Chief Justice engaged you fairly lengthily on this issue, but speaking for myself, I'm still in the dark as to whether you are saying of all organs of state, the National Assembly is not bound by a remedial action taken by the public protector.
That's the purview.
The National Assembly can do its scrutinization
It is the
to a point of finding differently from the public protector.
That is indeed our submission. It is the repository of the power.
Now I understand.
Yes.
Ms.
It is the repository of the power.
I'm sorry, Council. Just this end. Here am I. Hello. Here we speak one person at a time. In other fora it may be different. Would you just wait for my colleagues to put their questions and take your time and respond? And again, always only respectfully, please. Very well.
Thank you, Deputy Chief Justice. Ms. Nkosi Thomas, are you saying to us, in carrying out its constitutional function of scrutinizing the President's report or conduct, the National Assembly was not doing so to see whether the President had complied with any such obligations as he had arising out of the remedial action of the public protector?
I would hate to repeat what I have already said, but the purpose of the exercise was to scrutinize the action with a view to determining whether or not there was a breach. And once a determination of a breach had occurred, only then could subsequent steps occur. And enforcement might as well have been one of them, but it's difficult to preempt before the interrogation and the engagement with the report has occurred.
Now, the breach that you are talking about, was that the breach, was that to determine whether there was a breach by the President of an obligation on him arising out of the remedial action of the public protector?
The breach that we submit was being probed is a breach of a constitutional obligation. And those constitutional obligations, there's the Code of Ethics that has been promulgated under the Executive Ethics Act, goes a long way with setting out and cataloging the nature, the standard of conduct that is expected of the executive. So those are the breaches that we...
Mr. Ngozi Thomas, can I ask I'm very interested in my colleague Zondo's question. I just want to ask it what I understand it to be in a slightly different way. How could Parliament determine its oversight of the President unless it took a view on whether the Public Protector's remedial action was binding? In other words, wasn't Parliament's function to scrutinize the President's response to the report in the light of its view as to whether that report was binding or not? You've told us that you're not going to take a view on whether the Public Protector's remedial action is binding. Now, how can Parliament perform its oversight function in relation to the President's response to the report unless it took a view?
Well, perhaps one should just make this submission up front that Parliament, in fact, took a view on that very question, namely whether or not the powers are binding, the remedial action, whether or not it is binding. It sought senior counsel's opinion. It considered the judgment, the Western Cape judgment, but the reason why I mentioned when I started my argument that we're not going to deal with that issue around whether or not it's binding was because, firstly, the public protector did not order Parliament to do anything. Hence our approach on the yardstick against which to gauge parliamentary action are the provisions of 43(2).
We're not talking about whether Parliament was bound by the remedial action. We're talking about how Parliament oversees the President's response to the remedial action if it's binding.
Miss we have mechanisms.
And just on that issue, Justice Cameron.
Ms. Thomas Kose, I thought allied to that issue, you would just make something clear whether Section 55(2), which you have avoided to place any reliance on, whether that section does not place an exclusive obligation on the National Assembly to oversee the conduct of the President.
It does. It does with respect. But what it prefaces, it speaks about mechanisms of enforcement of the power. That's how we read it. So mechanisms, procedures of exercising the power, as we read the Constitution, that is to be sourced from 42(3).
Yes, I thought it would be allied to what my brother, Justice Cameron, asked. You may proceed to respond to his question.
Well, as far as the question from Justice Cameron is concerned, on the facts of this case, Parliament, indeed, the National Assembly, through its ad hoc committee, gave consideration to the question of whether or not the powers of the public protector are binding or not. It took a view based on the judgment in the Western Cape Division of the High Court. It is not binding because at the time, that was the pronouncement on the question. And took that into account together with everything else that was before it and acted accordingly.
Thank you very much, Ms. Nkosi Thomas. If Parliament was wrong, as Mr. Gauntlet and other counsel who've preceded you agree now because the remedial action in this case was binding, then Parliament failed effectively to oversee the President.
It's a question, of course, of an error of law. The question is whether it's material, and that's where it goes. And I beg your pardon, please. So it goes to a material error of law. I mean, that much must be correct. But at the time, it considered itself to be acting within the four corners of the law.
We're not questioning Parliament's motives at this stage, and Mr. Trengove, in his address, didn't persist in questioning the President's motives. We're simply interested in whether there was a failure of parliamentary oversight of the executive.
Well, in that regard, the question becomes one of rationality. But the fact of the matter, Justice Cameron, is that there is no gainsaying that the Western Cape judgment was overturned in due course, and that's what was taken into account. So I guess the high watermark of the submission that we can make in that regard is that the rational connection, based on the material that was before Parliament at the time.
I'm sorry to persist, but it's important because you are here representing the National Assembly. We now understand that the President, because of an erroneous view of the force, the binding force of the Public Protector's remedial action, made a mistake in not implementing it. Doesn't it follow that Parliament also made a mistake in failing to oversee him because it thought that the recommendations weren't binding?
Well,
you are thinking, Ms. Ngosi Thomas, particularly in view of the SCA judgment on SABC.
There is no gainsaying, Chief Justice, that Parliament acted on a wrong principle, thinking at the time that the principle was correct. That's all we can submit in that regard.
And is it fair to assume that the position taken in Parliament's written submission has now changed in view of the SABC decision? In relation to the remedial powers of the public protector?
Yes.
And perhaps then to wrap it all up, what do we do with the ad hoc committee report and its findings? What do you say we do with them?
Well, the DA, the relief that's been sought is to set aside 2 decisions of the National Assembly. The first one establishes, is the second one that, let me start with the second one. The second one adopts the report of the Minister of Police. And the first one directs the Minister of Police inter alia to perform certain duties to assist the National Assembly in its scrutiny functions. So it must follow that if this court takes the view that Parliament should not have done more.
No, I just need a direct submission from you, please. Let's get there. I just want counsel to make a submission on what you say, as a representative of Parliament, we should do with those 2 decisions. In the light of everything we've said this afternoon, it's late in the day, what is your submission?
Deputy Chief Justice, we submit really that Parliament was acting in terms of 42.3, and hence those resolutions came about. But of course, if this court is not with us and the court is not inclined to find that that was part of scrutinizing, then it must follow that the resolution fall to be set aside.
In relation to DA's conditional application for direct access, the Speaker makes submissions at paragraph 83 of the heads of arguments that the application must fail, and one of the reasons in paragraph 83 appears at 83.5. It reads, contrary to DA's contention, the issue that arise in the DA and EFF application are far from identical. In the DA's application, relief in the form of a partial review is being sought, whereas in the EF application, a declarator that Parliament failed to fulfill a constitutional obligation is at issue. On this basis, a suggestion is made that the application should fail. Now, DA deals with this contention in paragraph 73 of its heads, read with footnote 98. What is your comment to that?
Well, I propose to make submissions in relation to jurisdiction. Now, take that into account as I make the submission. This matter has now, the issue of jurisdiction has now been in our submission being overtaken by events. There's now a concession by the President, and in other words, the matter is halfway resolved, so as to suggest that to remit the matter to the High Court might just not be practical in the circumstances. The only issue that we wish to raise is that, my colleague Mr. Trengrove, in the context of the jurisdiction, his jurisdiction argument, mentioned that this issue around the powers of the public protector has enjoyed the attention of other courts, in the sense that the High Court in Cape Town has dealt with it, although in a different context, SABC matter, and the SCA has dealt with it. The only issue that we wish to highlight in that regard is that this issue, to the extent that it affects the National Assembly, has not served before any other forum. That's the only submission that we wish to make. But we are not persisting with the submissions that this court should not. So we pretty much leave the matter in the hands of the court, realizing that there has already been a lot of developments.
What you say is that you do not persist with that submission.
We don't persist. We highlight, however, that the issue of the powers of the public prosecutor in relation to the National Assembly has not enjoyed as yet the multi-stage judicial attention. That's all we wish to say in that regard.
One last question from me, Ms. Thomas, is merely out of interest. I want to know whether it is usual that the National Assembly takes this long. In this case, it was about 14 months to scrutinize an issue in overseeing the executive action.
Don't have instructions, Justice Rampepe, on the issue, but considering the extensive investigations that were undertaken by different organs of state and the quantum of the executive action involved, perhaps it's justifiable, but I'm unable to say whether it's usual or unusual. I am unable to assist the court in that regard.
Thank you.
Just to make sure that I understand where the National Assembly stands, did the National Assembly err in the manner it approached the remedial action taken by the public protector with a view to ensuring that accountability kicks in from the side of the executive? Or is it a question of Section 42(3), or are you leaving the matter in our hands?
We've made our submissions, Chief Justice.
No, I'm not sure anymore, so I needed some guidance. I don't want to impute to the National Assembly something that it doesn't say. Remember, initially you said 42(3). Afterwards, I thought I heard you say the National Assembly made a mistake informed by the decision of the Western Cape Division of the High Court. Subsequently, I thought you were back to 42(3). I'm not sure.
May I clarify the submissions that we made?
Please.
Parliament, when it received the report, acted in terms of what it understood to be its scrutiny, powers of scrutiny and oversight in terms of 42(3). Hence, it felt that it needed to apply its mind, and it considered all the evidence, all the reports that were before it. In doing that, in scrutinizing and analyzing the executive action that was the subject of the inquiry, it considered the law at the time, the law as it pertained. It sought a senior counsel's opinion. It sought also, it took into account the judgment, the Western Cape judgment, before it was overturned. Having taken all of those factors into account, it took a resolution on the 14th, the 2014 resolution. That's the first impugned resolution. And the first impugned resolution sought assistance from what it considered to be security experts. When that report came, it considered the report and it adopted it. So that's the long and short of it. So in terms of whether an error of law, the submission is that Parliament took into account what it considered itself entitled to take into account in terms of 42.3.
Thank you, Ms. Ngozi Thomas.
Well, there's one matter that we wish to deal with, and that is the condonation of the late filing of the Speaker's answering affidavit. Although this, in the EFF case, oh, you know, my learned friend, Mr. Trengrove, says to me that they're not opposing it, but I wish to, just for the sake of good order, to move for the condonation, and the grounds are set out in the application. Those are submissions.
Thank you very much, Ms. Ngozi Thomas. Mr. Mukari.
Chief Justice, I'm waiting for my junior assistant just to come closer to me.
Yes. You had indicated that you may not have to say anything. I don't know where you stand now. For the purpose of the proper management and
yes,
fair management of the matter, have you decided to make submissions?
Yes, indeed, Chief Justice. I did say that I may not say anything depending on what the DA is going to say, but I did speak to my learned friend for the DA, who informed me that he's persisting with the relief which they seek against the minister. So I'm going to make submissions only in that regard. But I still stand by what I said, that I am going to require only 15 minutes. But that's because knowing that as the last speaker, I was mindful of the fact that a lot of things then would have been said by the previous speakers, which will not require repetition. So that is basically then why then I thought that it would not be necessary for me to detain this court for much longer.
Should we refrain from interrupting you for 5 minutes? Or
just for 5 minutes.
Are you in the same position as Ms. Steinbank? You don't mind being interrupted from the word go?
Well, just for 5 minutes, Chief Justice, because of the developments which have taken place then in this matter, so that I can put in a proper perspective as to how then in our submissions this court should deal with the report of the minister. Chief Justice, as you are aware that in the past few days the train has been moving too fast, almost leaving us behind, and the submissions have been made on behalf of the President as to what is the stance of the President. And in my submission, that actually has to be taken into account because it does change the complexion of how then this court may have to deal with this matter, and also how this court may have to deal with the report of the report of the minister. I mean, what we know by now is that the President, and repeated through his counsel, was a commitment by him then to pay a reasonable portion of the amount or the costs which have been expended in Nkandla residence, and he also then seek then direction in respect of who then is to do that, and he has also then proposed to this court that the Minister of Police will not really be party then to that. Of course, then we understand then the position of the President to be a determination by him then to get the matter resolved, not necessarily to say that this court should, under normal circumstances, then take direct access of these particular matters then and deal with them in the manner in which they have to be dealt with. So then I'm going to simply then highlight then certain topics which I would like to deal with, just to indicate to the court what has been the stance of the minister right from the beginning in the context of the report that he finally drafted and submitted to Parliament for adoption. I have 4 topics which I would like to deal with. The first topic is the process that was followed leading to the adoption of the minister's report by the National Assembly. And in that regard, I'm going to simply, in point form, refer the court to the relevant pages and page numbers so that then the court can have the sequence of events up to the end, and that will take me only 2 minutes. Then the second topic relates to the status of the Public Protector's report, but again, it will take me 2 minutes because it relates to what our position has always been in the answering affidavit of the Minister. The third then topic will be whether the Public Protector's report was to be subjected to parliamentary process before it could be taken on judicial review by any of the affected parties, of course, then we know that. And the last topic, which is the fourth topic, is then the legal status of the Minister's report in the scheme of things. Well, of course, I'm saying in the context of the developments which have happened and which we know where then the President stands now. With regard to the first topic, I'd like to refer the court then to the following pages. The process was triggered after the Public Protector released her report in March. Then on the 2nd of April 2014, and is a letter from the President to the Speaker, and that will be at page 785. And that is what then now triggered then the process which culminated in the drafting of the report by the Minister. Then the second then will be the report to the Speaker of the National Assembly by the President, and that will be at page 502. And then the third will be an establishment of an ad hoc committee to advise, to consider the report or the Nkandla report by the President, and that is at page 813. And when I refer to these pages, I'm actually then working on the DA's papers and not the EFF's papers. So that is page 813, and that was actually on the 19th of August 2014. And then the fourth then instance then was now a letter to the Minister of Police by the Speaker, and that will be at page 829, is a letter dated the 29th of December 2014. And then the fifth instance then was the Minister of Police report. Then of course then we know then the instruction that was given to him was that he should investigate with assistance of the security experts as to whether then those items which have been identified by the Public Protector have or constitute the security measures. And that of course then is at page 589. And that is a report dated the 22nd of March 2015. And then from there, then the sixth incident then was the report of an ad hoc committee to consider the report of the Minister of Police at page 644, and that is now 7th August 2015. And then finally, then it was the adoption of the Minister of Police report, then the 7th of August 2015. And finally, then we know that it was submitted to the National Assembly and it was debated there. Motions were placed before the National Assembly, and that report was finally adopted by the National Assembly. I think it was on the 18th of August. Then, so that is then basically then the history that then took place, leading to the drafting of the report. Then, but then before then I even go to the second then. A point which deals with the status of the Public Protector's report. As I understand the DA's attack on the Public Protector, on the Minister's report, is that the National Assembly had no authority to mandate the Minister to investigate in the manner in which they wanted him to investigate and to prepare that report. So, in law, then the Minister's report is subsidiary. So it means that it is entirely dependent on whether this court holds that the National Assembly did have that power. If it didn't have that power, then as a subsidiarity to that which was done by the National Assembly, then that report, of course, then will suffer those consequences. So that is basically then how we understand then the law. But let's look at the second topic.
The content of the power, you went quickly there, Mr. Makari. Power to do what?
I didn't get the question, Deputy Chief Justice.
You said it depends on whether the National Assembly had the power to do something.
Precisely.
My question is the power to do what?
Well, whether the National Assembly had the power to order the minister or to instruct the minister in terms of the powers which are exercised by the National Assembly in terms of Section 55(2) to go and investigate with assistance of the security experts and prepare a report and submit it to it. So that is the specific instruction that was given to the minister. So it is in that context. As I understand, the submissions that were made on behalf of the National Assembly is that the National Assembly dealt with that matter then in the context of those powers conferred by it by Section 55(2). But of course, I'm not going to really debate what was in the mind of the National Assembly, because that is not for us for consideration as the minister. All what we know ourselves is we were informed, exactly specific instructions were given to us as to what is it that we have to do, and we've done exactly that. But then the question will be, the one who gave us that instruction, did he have that power to do so? So that's why then I'm saying that then the report of the minister is entirely dependent on the authority which then the National Assembly then had.
What are your instructions? What's your attitude?
Well, our instruction was that...
Was the minister's report procured in accordance with law?
Well, there are two ways then to deal with it. So first, it is on substance and on process, but the third one, of course, then on the question of legality. Then on process, then it seems as if there is no quarrel about by anybody that the process then was fine, the way in which then it went up to the end. But on substance, then I don't see any issue that goes into what is the content of the report. But on legality, then is actually then the issue of authority. And that issue, of course, as I say, I cannot make that submission on behalf of the National Assembly. But I accept that the legality of the minister's report is entirely dependent on the lawfulness of the report.
Well, the real substantive question is whether the minister, it was open to the minister to second-guess the decision of the public protector. Was it?
Well, I don't think so. But all I can say is, when we look at the instruction, he had to execute the instruction that was given to him. The instruction that was given to him had nothing to do with the public protector's report that he should actually review it or second-guess it. The instruction was very clear. Go and investigate with the assistance of the security experts whether then the features that the public protector then found to be non-security are indeed so. So my submission is that in law, this court has already found in Nkandla investment what is the status of the administrative function. And the SCA has already ruled on that issue in eau de grâce. So once then that instruction is given, I cannot imagine that it's up to the minister then to actually decide and say to the National Assembly, I think you are acting unlawfully when you say I must do this. Because to do so is to unscramble exactly what this court has already said in Nkandla investment. So that's why I'm saying that the minister's hands actually were tied. He has to make sure that as part of an executive, he has to perform a duty given to him by the National Assembly, and he will only be wrong if he does that duty not in accordance with the instruction. There is no suggestion whatsoever that the instruction that was given to him, he did it contrary to the instruction.
Well, let's cut to the chase. Is it your submission at all that we ought to uphold the resolution of the National Assembly? Or
all what I'm saying...
You're not there at all?
All what I'm saying is the following. With what has now happened, the minister's report and the resolution of the ad hoc committee and the resolution of the National Assembly become water under the bridge. Because now we know, on the primary question of whether or not the president should pay, that issue has been resolved. So then there is no need for this court, under than the principle of direct access, to then deal with this too.
Well, you're watching SABC News, and you've just been watching live visuals from the Constitutional Court in Braamfontein, Johannesburg. Well, that much anticipated hearing into the powers of the public protector got underway this morning already.
Nothing has been demonstrated in that context. But I was not saying that this court must take a technical view to that. We are simply saying that once the principal issue has been dealt with and has been considered, and the president has shown a commitment that he's going to pay, all then what happened thereafter, this court will not really... So those are really then our submissions in that regard.
But Mr. Mkara,
Justice Jefta.
was the report, correct me if I'm wrong, was the report by the minister at the behest of the president or the National Assembly?
Both. But he executed the instruction of the National Assembly. It just happened that coincidentally then both of them were giving instruction, but then it was from both, yes.
Both determine the same terms of reference.
Well, I'm not sure. I don't have that report from the president. I think it's paragraph 6.3 and 6.4. Then they'll get a page number for me. More or less, but not verbatim, yes.
Mukari, perhaps we can assist you in relation to the question by my brother Jafta. If you look at the terms of reference.
What page would that be, Justice Kabine?
It's volume 4 of DA's papers, page 520.
Page?
520.
Yes, I have the page.
Paragraph 64, where the president says that deem the following to be appropriate. 632, the Minister of Police as the designated minister under the National Key Points Act to report to Cabinet on a determination to whether the President is liable for any contribution in respect of the security upgrades having regard to the legislation, past practices, culture, and findings contained in the respective reports. So it seems to be clear here that it was the instruction by the President and not the National Assembly.
Yes, that's why I said that both of them gave the instruction. I mean, the President gave the instruction, Justice Kabindi, you're correct, but then there was also the instruction then from the National Assembly. But we know that the instruction from the National Assembly, then it went to the Executive or to Cabinet, that then this what must be done. And then, of course, then Cabinet took it upon his wisdom that the functionary that is vested with the authority to deal with matters of security of presidents, deputy presidents, and so on is actually the Minister of Police. So let it be the one who must deal with it. But there seemed to be no contention that the instruction then, of course, then came from both of them. It may be on different occasions, not necessarily verbatim, but the context and the substance is the same.
As to the records where the instruction by the National Assembly is reflected, just for clarity?
Yes, I was referring to the letter dated 29 December 2014, which I've already referred to it when I was dealing with the sequence of events. That will be page 829. Page 829 is a letter dated 29 December 2014, and that letter is addressed to the Minister. And when you look at it, then the letter comes from Parliament. At the bottom of it is signed by the Speaker of the National Assembly. And it says, report of ad hoc committee to consider the report by the President regarding the security upgrades at the Nkandla private residence of the President. And then from there, then he sets out then what he wants then to happen. We draw your attention to the report of the above ad hoc committee, which appeared in the announcements and so on and so on. Well, as I see, I remember that there was a question from the bench, I don't know then which justice it was, about why did it take so long. The court will realize that the public protest report was in March 2014, and then it was towards the end of the term of the fourth parliament. And the elections were exactly in May, 2 months later. There was an ad hoc report, ad hoc committee which was set up, which was then dissolved when the fourth parliament then came to an end. When the fifth parliament then came into office, then the ad hoc committee was resuscitated. So then that then is actually then there was a bit of a long process which was interrupted by the fact that there was a transition from the fourth parliament then to the fifth parliament.
Let me just make sure I understand your position, Mr. Mukari.
Yes.
Your instructions from the Minister of Police is simply to explain how you got involved,
yes,
and not to express or to make any submissions on the validity or otherwise of any of the mandates that you were given by the National Assembly or the President. You are not to touch any of those issues.
Okay.
Is that correct?
Yes. So the answer then is page 829 of the letter dated 29 December 2014, paragraphs A, B, and C that specifically set out. The National Assembly, among others, recommends the following: a technical team of qualified security experts from the State Security.
I'm not there.
Oh, okay.
I'm saying, am I correct in saying that you are here not to make any submission on the correctness or otherwise of the mandate given to the Minister of Police by the National Assembly, the correctness or otherwise of the mandate given by the President to the Minister of Police? You are here instructed by the Minister of Police only to explain how he got involved.
Precisely. All right. So the Chief Justice got me right. Well, on the powers of the public protector, then, I mean, when I take the court then to paragraph 42 of the answering affidavit, which appears at page 863, our position has always been clear that this issue to us was in fact a non-issue because it has been resolved by the SCA in the Maiden Guardian judgment in 2011. That, I mean, and also it was actually then, even before then, the Maiden Guardian in 2011, in 2001 or 2002, then the Declaratory has made it very clear. A performance of an administrative act, then once it is made, then it has legal effect and it carries legal consequences. So as to why this then became an issue, I was surprised.
I don't understand anymore. How then could you have made the recommendations that were made by the Minister of Police, knowing that the public protector's remedial action stands?
Well, then if I take your, then the court to page 852, again, then that is now then the answering affidavit of the Minister. So paragraphs 18 and paragraph 20, it deals with this issue. And in the context of the following, that the public protector can prepare various forms of reports. She may prepare a report which may require that it has to go to Parliament. Of course, then when it involves in the then there's an involvement of the Executive Ethics Code and so on. Or she may come with a report which entirely requires an administrative functionary to do something. That report does not have to go to Parliament. So what we say then here is that the nature of the report which was prepared by the public protector is the one that she contemplated that it should go to Parliament and it must be dealt with then by Parliament. And we say that on that basis, then the report ought to have been first processed through the parliamentary processes, and it's only at the end. And I remember, Chief Justice, and you raised that issue then with our learned friend then full corruption watch, that they may, at the end, decide then to, if they've conducted their own investigation, which comes to a different conclusion to that of the public protector, still then now say, we don't agree with it and we're taking it on review. So that's why then in the answer affidavit of the Minister is that that process was not yet there, or were not yet there that it can be taken on judicial review, because it was one which the public protector has subjected it to Parliament, and in fact we have quoted certain excerpts from her own letters with the engagement, when she had engagement with the President, where she was actually, with the Parliament, where she was saying that I'm aware and that this report is actually then being processed or underway then through the parliamentary process. So then we're saying that for what we're doing, sorry, Chief Justice.
Mr. Mkari, the Chief Justice sought a response from you, and more particularly, it was about the legal status of the remedial action.
Yes.
And you assured us that this is old hat. It had been said in Mail and Guardian, it had been said in Declaratory, had been said in Kirland, and so you advised your client. And he followed up with a question that says, if it was all this crystal clear, why at all was your client part of the process to second guess the remedial action? That's what you were asked. Do you want to confront that question, please?
My response was Odekral, and my response was then Killand Investment, that first is he receiving instruction from an organ which has an authority over him. If the answer is yes, then he accepts the instruction.
If it was open to the minister, he well could have said, according to what I understand you say, this is all unlawful, but I'll do it because you so instruct me. Is that what you're saying?
Well, he may or he may not. He may have said, yes, it is all unlawful, but I'll do it, or he may not have said that. So then that is really then, a question which I cannot then really answer, but he may or he may not. But what we know is that as a matter of law, once he receives an instruction from a body which has authority over him, he must carry that instruction, because if he does not, then we are actually doing then exactly the opposite of what this court told us in Killand.
Well, let's step away from the proposition. It's a very dangerous one. That a state official, a cabinet minister, acted knowingly that he was acting unlawfully. I don't think you want to repeat that lightly.
No, I'm not suggesting that at all. That's not what I'm saying at all. I don't want the court then to misunderstand my submission. Okay. I'm not saying that at all, that he was acting unlawful. All what I'm saying is that the minister has received an instruction from an organ which then has an oversight power or role over him, and he carried that instruction to the latter, unless if then it can be shown that he deviated from that instruction. That's what I'm saying.
But he well knew what the law was about the remedial power of the public protector, did he?
No. That is a submission from me as a lawyer, that insofar as the legal effect of an Administrative Act, that has been settled law. And then, Deputy Chief Justice, you will also then realize when you look at the timing in terms of when the answering affidavit of the minister was signed, that unlike the President and the National Assembly Speaker in the EFF matter, he already had the benefit of the SCA judgment, which actually then was already out in the SABC matter. So then we should then actually extrapolate him from being actually somebody with the knowledge of law.
Okay,
but of course, we rely then on legal advice.
Let's finish it off now. Your attitude and that of your client is that remedial action contemplated in the Constitution is binding.
Yes.
Unless set aside.
Yes, that is the law.
And that is your position of your client too. Very well.
That is the law.
Yeah. And it must follow that the report, the recommendations he made, that it be all set aside or not followed, would be inconsistent with that understanding of the law, isn't it?
Yes. Well, what I was saying is that the law is very clear that if you do not like it, you can't ignore it, you take it on judicial review. And we say that that is settled law.
And any report that purports to set it aside, other than on review, would have no force in law, would it?
No, you'll have no force in law. Our report, once then this court accepts the proposal from the President, this court did not detain itself with the subsequent events which happened, because then the law is very clear. Then they are really of no consequence in law. So all I'm saying is that we don't want to argue direct access, neither do we want to say that we are arguing it, but all what we want to say is that insofar as the court having not to deal with the issue of direct access, because insofar as direct access is concerned, insofar as the DA wanting to then to set aside the minister's report, we say that they have not made out a case for direct access. But we don't want the court to go there. We're simply saying that the court should simply, once then it deals with what the President has put as a proposal, then it should simply then say that all other actions which happen thereafter then were of no legal consequence.
I hear the point. You've made the concession, but you say, please don't go there. We understand that, yeah.
Well, I'm saying that don't go there because then it's not the forum that you should really concern yourself much with, actually.
Well, I thought I was saving you all the trouble when I asked you the question I asked you earlier.
Indeed.
You are here to say only this. and nothing more. But anyway, thank you, Mr. Mukari.
Chief Justice, yes.
Thank you.
Thank you very much. Those will be our submissions, and insofar as costs are concerned, we leave it in the hands of the court.
Thank you very much, Mr. Mukari. We're going to take a 15-minute tea break. The court will adjourn.
Well, you've been watching live visuals from the Constitutional Court in Braamfontein in Johannesburg, that much anticipated hearing into the powers of the public protector really got underway this morning already. It's expected to settle the dispute over whether President Jacob Zuma is really obliged to pay back the money for non-security features at his private Nkandla residence. Now we'll be dipping into and out of the court for the rest of the afternoon. Proceedings have been adjourned for about 15 minutes, we understand. In the last few minutes now, we've been hearing from Advocate William Mukari, appearing for the Police Minister. He really delved into the legal status of the Minister's report, going through the history and background that led to this particular report. Advocate Mukari raising the question of whether the National Assembly had the power or authority to instruct the Police Minister to investigate and report on Nkandla. Now the Chief Justices really cutting to this chase this afternoon, asking him whether the Minister second-guessed the Public Protector on this one. Advocate Mukari saying that once the Police Minister receives an order from an organ of state which has an oversight role over him, he must then carry out that particular instruction. In the last hour or so, we also saw Advocate Lindy Nkosi Thomas appearing for the National Assembly, making her submission. Now, there was much focus this morning, especially during the DA's submission, on whether the National Assembly and indeed the President defy or ignore the Public Protector's remedial actions. The EFF and the DA maintaining really that the measures taken by the President and the National Assembly fell short of complying with the Public Protector's remedial actions in her report. Now, Chief Justice Mogoeng definitely not going easy on Advocate Thomas this afternoon. Essentially, he's questioning the constitutional role, the functions and requirements of the National Assembly in this particular matter. Thomas maintaining that the Public Protector cannot dictate or instruct Parliament. Justice Cameron raising the pertinent question of whether there was a failure of parliamentary oversight of the executive. Let's move on now. Here are some of the statements that were made earlier in the hearing.
You would have seen from the letter which we directed to the other parties and to the courts, seeking to make plain our position and seeing not if we could settle this case, because that has been the way, unfortunately, it has been portrayed very largely in the media, but in an open and transparent way, proposing that which could bring an end to what has been a protracted and very difficult issue which has traumatized the nation in many ways. But the critical thing that we don't want to be seen to be doing in any respect is to obstruct what we in fact are asking for, that you make an order to help this issue be cleaned up.
The National Assembly has a particular duty to call the President to account in this case. Firstly, because it's the only institution that can call him to account. Nobody else can. Everybody else in the executive can be called to account by the President or his cabinet. But the President can only be called to account by the National Assembly. So it's a very important tool. And the National Assembly has the ultimate power of dismissal. It failed in its failure, it violated the Constitution in its failure to call him to account at all. And it's enough for us to demonstrate that it failed in that constitutional duty. It is unnecessary for us to go further.
One of the features which I will come to, which is a case is made out on these papers by the DA, that there was obstructionism or there was obstruction and defiance of the worst kind, not at the moment her remedial action was taken, but from the beginning, when she started investigating. And that will, we would submit, influence the court as to how it deals with this question of defiance.
Well, Advocate Lindy Nkosi Thomas was representing the National Assembly, and she did have a tough time.
Does the National Assembly accept as correct the meaning given to the Public Protector's remedial action, to the benefit of all the written submissions and oral submissions in court, as articulated by those who came before you?
Chief Justice, how am I going to, it's not necessary to deal with that question insofar as the actions of the National Assembly are concerned in this matter. In order to determine whether the National Assembly has acted properly or not, it's not necessary to deal with whether the powers are binding or not, because firstly, the Public Protector did not direct the National Assembly to do anything. So the question of whether or not the Assembly was bound by this report does not arise on the facts of this case. That's the first thing. But the second submission that we wish to make in that regard is that the powers of Parliament, such as they are such that they cannot be fettered by any Chapter 9 institution, and that institution with respect includes the Public Protector with respect. And when the President reported in terms of the Ethics Act, the general powers of the Assembly of oversight and accountability and scrutiny arose. And that's hence, it's not necessary for us to determine that. That issue is not determinative of how our client has gone about.
When the report of the Public Protector was received by Parliament and the report by the President was received by the National Assembly, what is it that the National Assembly was, in terms of the Constitution, required to do?
Yes.
You see, we need to find out, first, what is it that it was required to do, and did it do what was required of it?
What the National Assembly was required to do, Chief Justice, was to scrutinize the executive action that was at the center of the report. It is the executive action that the National Assembly has oversight powers over.
Within the context of the findings of the Public Protector and the remedial action taken.
The Public Protector, what the Public Protector did, took remedial action against the President, not against the National Assembly.
Oh, that is a common cause, I think.
Having done so, he said, you report yourself to your master in terms of the Ethics Act, because you must account to your master, who is the National Assembly, with your comments and the actions taken.
Well, our reporter, that's Aldrin Sampier, has been monitoring the proceedings at the Constitutional Court in Braamfontein from this morning. Good afternoon, Aldrin. Welcome to News Today. It's been a long day for you, Aldrin. Advocate Mukari appearing for the Police Minister, really delving into the legal status and the background and history of the Police Minister's report. Just take us through the key points of his argument this afternoon, Aldrin.
Well, basically, if you heard earlier on, the Chief Justice asking Advocate Mukari what exactly is he here to do, and he did say that I'm here just to explain why or how the Police Minister got involved in this Nkandla saga, saying that there was an instruction from the President that he should investigate how much is to pay, or if there's anything to pay. And that's exactly what he did. Well, what the Chief Justice as well as the Deputy Justice seem to have been grappling with is whether this instruction from the President or even the Minister accepting this instruction was that he was acting unlawful, whether he knew that he was acting unlawful, considering that Advocate Mukari conceded that you cannot second-guess the Public Protector's findings. The Public Protector's findings can only be taken under review, and it cannot be taken under review by a Member of Parliament, whether it cannot be taken under review by a Member of Parliament or a Cabinet Minister.
Aldrin, we also heard in the last hour Advocate Lindy Nkosi Thomas appearing for the National Assembly. And we heard Justice Cameron raising the very pertinent question of whether there was indeed a failure of parliamentary oversight of the executive when it came to overseeing the President.
And remember that that's an argument that's been set out by the EFF in their heads of arguments, that Parliament failed to hold the Cabinet accountable, they failed to hold the President accountable as well. And the role that's being asked right from Advocate Lindy is what exactly is the role of the National Assembly, considering that the Public Protector had made her findings and then instructed the President to report back to Parliament in terms of his findings, or how he will implement those remedial actions, the remedial action instituted by the Public Protector. Well, Advocate Lindy was arguing that at that point, the only judicial paper that they had in front of them that they could use at the disposal was that High Court ruling in the Hlaudi Mutwening matter, the SABC matter, which spoke about the powers of the Public Protector, indicating that the Public Protector's findings or the powers are not binding. So that was on that basis that they considered that they were playing their role right up until the end, and whether or not they failed to hold the Minister, or rather the President, to account, there will be a decision that has to be taken by the Constitutional Court.
Well, just after lunch, we had Senior Counsel for the President, that's Jeremy Gauntlet himself, appearing and making his submissions. And he made some interesting points, Aldrin, saying the media wrongly framed the President's proposal as an attempt to settle this matter, and that the President accepts and he wants to comply with the Protector's report. Just take us through the key points of Gauntlet's submission this afternoon.
Well, actually, from Jeremy Gauntlet, they're representing the President. Major concessions coming through there, especially the one where he conceded that the Public Protector's findings are binding. And this is because if you consider the history of the Nkandla saga, when the supplementary or the first preliminary report by the Public Protector was released, the President indicated that he will not pay any money back because he did not ask for those upgrades. But now the argument was that around whether the President should have taken the findings of the Public Protector under review. He did not do that. And considering that he did not do that, that means that the Public Protector's findings are binding and the President should have paid back the money. And that's the concession coming through from Jeremy Gauntlet, who's representing the President.
All right, Aldrin, this is essentially a case, we understand, to determine the legal certainty of the strength of the powers of the Public Protector, right? Now, we heard the submission earlier by the Corruption Watch advocate, Carol Steinberg. How did she hold up in court?
Well, just before we get to the... speak to the Public Protector. She's joining us. Public Protector, let's just first start with looking at the number of parties that are involved in this case. That is all overwhelm you to see how many parties have come out to your defense, your office defense.
It's been quite encouraging. Not only the ones that are in defense of our office's powers, but we've also been encouraged by the ones who were objecting to those powers, and they've subsequently looked at the Constitution and the Supreme Court of Appeal judgment, and they've now made concessions, and we're very happy about that.
Do you think it was drawn out for too long, considering that now we have a concession from the President that the powers of the Public Protector or the remedial action is actually binding up until you take it under review?
Well, it was drawn out. It was said that it was drawn out, but as people keep arguing, they thought that they were right, and now that they are persuaded that they were wrong, it's a good thing that they have come to terms with the decision I made.
And when the president made a proposal to you, when the president made the proposal around paying back the money, also indicated that he wants the Auditor General to be part of the legal team, or to be part of the team that will consider or determine how much money should be paid back. And this is something that your office does not agree with.
Well,
Well, apologies for that break in transmission. That was Aldrin Sampier speaking there to Public Protector Thuli Madonsela on some of the concessions made today, with Counsel for the President recognizing that the powers of the Public Protector are indeed binding and that they will comply with her remedial actions. Well, time to take a short break. We'll be back with more news after this.
In Africa, technology has created many new ways of doing things.
ICT is an increasingly important part of everybody's life.
It's being used in education, for social media, and now for farming too.
The best thing about internet for a farmer is that you get to share information.
On Network, we give you all the important African technology and social media news. That's Network with me, Spumelele Zondi, every Sunday at 7:30 p.m. Central African Time, only on SABC News.
Are you saying the king must go to jail? You are not royal blood, therefore you are going to serve time on behalf of the king. Where does the public protector stand on this matter? Are you with the marches, for the marches, against the march?
If this is your ancestor, it is very much his ancestor as well, because this is the cradle of humankind. Is there God somewhere in your science? Drinking the blood of a person with albinism gives extra magical powers. A man of the cloth is involved here because it would mean that somehow religion is being brought into this part of the myth. What do you say to me?
Watch Question Time with me, Mpho Tsedu, Monday to Thursday at 5:30 p.m. on the SABC News Channel.
Well, you're watching SABC News. Here are some of the statements that were made earlier in the Constitutional Court hearing.
Does the National Assembly accept as correct the meaning given to the Public Protector's remedial action to the benefit of all the written submissions and oral submissions in court, as articulated by those who came before you?
Chief Justice, it's not necessary to deal with that question insofar as the actions of the National Assembly are concerned in this matter. In order to determine whether the National Assembly has acted properly or not, it's not necessary to deal with whether the powers are binding or not, because firstly, the Public Protector did not direct the National Assembly to do anything. So the question of whether or not the Assembly was bound by this report does not arise on the facts of this case. That's the first thing. But the second submission that we wish to make in that regard is that the powers of Parliament, such as they are such that they cannot be fettered by any Chapter 9 institution, and that institution with respect includes the Public Protector with respect. And when the President reported in terms of the Ethics Act, the general powers of the Assembly of oversight and accountability and scrutiny arose. And
Yes.
that's hence, it's not necessary for us to determine that. That issue is not determinative of how
Yes.
our client has gone about.
When the report of the public protector was received by Parliament and the report by the President was received by the National Assembly, what is it that the National Assembly was, in terms of the Constitution, required to do?
Yes.
You see, we need to find out first, what is it that it was required to do, and did it do what was required of it?
What the National Assembly was required to do, Chief Justice.
That was Advocate Lyndon Nkosi Thomas appearing for the National Assembly, making her submission a little bit earlier on in the afternoon. While those constitutional court proceedings have recommenced, let's listen in.
We have a president and an assembly who treated the public protector with disrespect for almost 2 years, in violation of the Constitution. Then simply to say, but I will pay back the money, is not good enough. That is why the EFF has always claimed, and still claims, declaratory orders to the effect now sought in paragraphs 1, 2, and 3 of their draft order. And let me motivate them very briefly. And I now refer to the draft order that was distributed a few days ago, but they're in line with the relief sought in the declaratory order that the protectors to take appropriate remedial action includes the power to issue directions binding on all organs of state. The public interest cries out for that clarification, finally conceded by all the parties in court, but for this court to give its imprimatur to that principle. Because
Mr. Fringo, sorry to interrupt. Would it be appropriate in paragraph 1 to add, unless set aside by a competent court of law?
Yes, indeed. Absolutely, because that's always been implied and we accept that. So that clarity needs to be brought in the public interest. Secondly, an order that the public protector's directions in paragraph 11.1 of her report were and remain binding on the President. That is necessary to vindicate the public protector. That is the position that she's taken consistently over the last 2 years since the release of her report, and that's the position that's been disputed by the President and by Parliament for almost 2 years. And it is important to vindicate the public protector for the very reason mentioned in paragraph section 181.3, namely to ensure the independence, impartiality, dignity and effectiveness of her office. The third is an order that the President failed to implement the directions of the public protector in breach of his oath of office and his duties under sections 83, 96 and 181.3 of the Constitution. That order is necessary to vindicate the Constitution. Once having found that the President has acted in breach of the Constitution for almost 2 years, it is incumbent on this court to devise an appropriate remedy. The very lowest, the very softest appropriate remedy is a declaratory order, one that declares that the President has acted in violation of the Constitution for almost 2 years. And with respect, such an order is necessary to vindicate the Constitution.
Sorry to breach our undertaking to you, but I'm worried about in breach of his oath of office, because you can surely breach your duties without bad faith. I take your point earlier about there being nothing on record to show bad faith. Does it necessarily follow that each time you fail to uphold the Constitution without evidence of bad faith that you also violate your oath of office?
Well, I submit with respect, yes, because the oath of office is, I will uphold the Constitution. If I don't, that is a breach of that undertaking. The breach might be a willful breach or an innocent breach, but there is a breach nonetheless. Sorry, Justice Cameron, may I also just add something about good faith or bad faith? Our learned friend, as I've said, has said that we accept the good faith of the President and Parliament. We don't at all. There is no evidence on record. What we have is a persistent conduct in breach of the Constitution for almost 2 years, and no explanation for it. If the President had come forward today and said, I am sorry, I had bad legal advice, I acted in accordance with the legal advice I had all along, and it was an error in good faith, that would have been a different matter. But you simply have silence. The suggestion that the President only got decent legal advice recently was made in the Sunday Times and not in the papers before the court. So that there is no explanation for the President's failure for all of this time since March 2014.
I'm not asking a question, I'm making a statement that you must reflect on.
That I must?
How else does a person who's not a lawyer change his or her mind in as drastic or radical a manner as the President did without the benefit of legal advice and accepting that the legal advice he had before was incorrect?
No, that's one possibility. Another possibility is that he had this advice all along, but decided to defy it. Our learned friend, Mr. Mokari, tells us that this outcome was obvious to lawyers all along. We simply don't know what the explanation is. The President hasn't offered any explanation. What we have is a persistent default for almost 2 years without explanation. So that I accept entirely, Chief Justice, that that might be the explanation. But it's not been offered. So you are left in the dark as to what the explanation might be. And we submit that in those circumstances, the least that you could do to vindicate the Constitution is to declare that the President acted in violation of those duties of his under the Constitution. I thank you, Chief Justice.
Thank you, Mr. Tringo. Mr. Gatz?
Thank you, Chief Justice. The DA in reply wishes to make effectively one point, but it's rolled up into 3 sub-points, if I may put it this way. The first is that there seems to be, and it's probably a relatively trite proposition that's not correct, that this court is limited in a sense to that which the public protector took as remedial action. This court is free to make whatever order it's to be just and equal discretion. So the debate that the Deputy Chief Justice had with Mr. Gauntlet as to the nature or the technical issues about some person walking around in Nkandla to determine the outcome is an inappropriate debate in the sense that this court can determine those issues. That's the first sub-point. The second sub-point is this. We agree with Mr. Trengrove to a point that the President, leave aside the National Assembly and the Minister of Police for a second, that the President has continually violated or continuously violated the Constitution for almost 2 years. The violation started in Nkandla, not with the remedial action taken. And we want to emphasize that. That's where the rot stepped in, not when the public protector issued her report. The President was found by her to have violated the Constitution much earlier than 2014. And the third point that I wish to make is this. The President seems to suggest that our client is here for, let's call it political reasons, as a precursor or provisional sentence for impeachment proceedings under Section 89. Let me place a fact on the table. One, my client's instructions are there has been no discussion whatsoever in caucus as to any suggestion of impeachment proceedings being brought. Not at all. But the problem with the suggestion by Mr. Gauntlet is this. My client comes to court with standing. The standing is set out in paragraphs 12 and following of the founding affidavit, and more particularly, it comes to court on the basis of Section 38, sub A, E, and in terms of D in the public interest. That's what it says, and that has not been challenged, and that standing in these types of situations has been accepted by this court on more than one occasion, in particularly the Similani judgment. And what we wish to emphasize is this, that when a litigant who has standing such as the DA, a political party, we cannot get away from that, makes a challenge to the lawfulness of conduct, it is inappropriate for the organ of state, the target of that challenge, to almost duck and dive by saying we will pay back the money. And for this proposition, we rely on Peko versus Ekurhuleni Metropolitan Municipality 2012, Volume 2, South African Law Reports 598, where Justice Nkandla made the point that even though those applicants had already been evicted from their homes, they were entitled to, and they had an interest in the adjudication of whether the rule of law had been violated. Similarly, my client comes to court and my client says the President, the National Assembly and the Minister of Police to the declaration to that effect if this court comes to the conclusion as it pleases.
Well, that was a live crossing to the Constitutional Court, where proceedings have resumed after a 15-minute recess. Apologies for that break-in transmission there. Now, we've just heard appearing for the EFF in reply is Advocate Trenkov in the last few minutes. He's saying that the Constitution was indeed breached for the past 2 years with no explanation from the President. Advocate Katz for the DA replying right now that the President had violated the Constitution, and that started in Nkandla, he says, and not when the Public Protector issued her report. Here are some of the earlier statements. Well, I understand we've got that link back up and running. Let's cross back to the Constitutional Court.
In fact, I have it here with me.
You can circulate it.
Can I have
later or give it to our registrars? Thank you very much.
That was the sole purpose of it. Is the response.
You are making submissions now.
It's the response to the proposal. That's it. Thank you, Chief Justice.
Thank you. Judgment is reserved and the court adjourns.
Well, that was a live crossing to the Constitutional Court where proceedings have adjourned for the day. Here are some of the earlier statements that were made during those proceedings.
You would have seen from the letter which we directed to the other parties and to the courts seeking to make plain our position and seeing not if we could settle this case, because that has been the way, unfortunately, it has been portrayed very largely in the media, but in an open and transparent way, proposing that which could bring an end to what has been a protracted and very difficult issue which has traumatized the nation in many ways. But the critical thing that we don't want to be seen to be doing in any respect is to obstruct what we in fact are asking for, that you make an order to help this issue be cleaned up.
The National Assembly has a particular duty to call the President to account in this case. Firstly, because it's the only institution that can call him to account. Nobody else can. Everybody else in the executive can be called to account by the President or his cabinet. But the President can only be called to account by the National Assembly. So it's a very important tool. And the National Assembly has the ultimate power of dismissal. It failed in its failure, it violated the Constitution in its failure to call him to account at all. And it's enough for us to demonstrate that it failed in that constitutional duty. It is unnecessary for us to go further.
One of the features which I will come to, which is a case is made out on these papers by the DA, that there was obstructionism or there was obstruction and defiance of the worst kind, not at the moment her remedial action was taken, but from the beginning, when she started investigating. And that will, we would submit, influence the court as to how it deals with this question of defiance.
All right, now for more, let's cross to our reporter, that's Aldrin Sampier. He's been monitoring proceedings at the Constitutional Court today very closely. Good afternoon again, Aldrin. Some big concessions from the legal counsel for the President, the Public Protector. How is she reacting?
Well, definitely, especially looking at Jeremy Gauntlet's concession that the President should have paid the money immediately after the Public Protector's report came out, or otherwise should have taken it under review. I think the other important thing out of this case and out of Gauntlet's submission is that the court should not take a declaratory order, should not make a declaratory order against the President. And this is with regards to upholding the Constitution and making sure that he protects the Constitution in terms of the oath of office that he has taken. Gauntlet's submission is that making such an order would lay the ground or the foundation for an impeachment which would happen at a later stage, while the DA's lawyer Anton Katz has indicated that there is no intention from the DA side to be using this ruling to make such to call for such an impeachment. We know from the EFF side, even last week already, when they had the press briefing responding to the President's proposal, that they indicated that the Nkandla matter does not end here. They will definitely go ahead with the matter and certainly call for the impeachment of the President because they want the President to step down.
Aldrin, earlier we heard from Advocate Trenkov for the EFF focusing on whether the National Assembly and the President indeed defied the Public Protector and did the President not uphold his constitutional duty to implement the remedial actions set out in the Public Protector's report. How did this argument hold up in court?
Well, and that's been the argument that has been sustained throughout the day, especially from the DA as well as the EFF, that the National Assembly had a duty to uphold the Constitution and to make sure that it holds the President as well as the Cabinet to account. And I guess the other issue that the judges will have to grapple with now, considering that the judgment has been reserved, is whether the National Assembly has failed to hold the President to account, considering that there was a Public Protector's report. We heard earlier on from Advocate Lindy Nkosi Thomas, who's representing the National Assembly Speaker, saying that when the National Assembly made a decision or adopted the reports from the police as well as from the ad hoc committee on Nkandla, it was on the basis of the High Court ruling with the SABC court case that happened in the Western Cape, where it indicated that the powers of the Public Protectors or the remedial action is not binding. So based on that, they can't be held at fault. It could be that it was a mistake or an error of law.
This was, we understand, essentially a case to determine the legal certainty or the strength of powers of the Public Protector. And we earlier heard a submission by Corruption Watch, which joined the case as a friend of the court, we understand, with Advocate Carol Steinberg coming to the fore. How did she hold up in court, Aldrin?
Well, the argument there from Corruption Watch was that what the court should consider here is compare this Chapter 9 institution, the Public Protector's Office, to another Chapter 9 institution, which is the Human Rights Commission, and where the law, the Constitution says that the Human Rights Commission must take steps to ensure that there are recommendations or remedies to cure certain situations or findings that it has made. But with the Public Protector's case, it's certainly and it's clear that the Public Protector has powers to institute remedial action.
Thank you, Aldrin. That was Aldrin Sampier coming to us outside the Constitutional Court in Braamfontein. Johannesburg. Judgment in that case has been reserved. I'll be back with more news at the top of the hour. You're watching News Today. It's just gone 1700 hours Central African time, and we are live from Johannesburg, South Africa. With your headlines, I'm Kirshni Govender. Yes, it's a big one for today. On the hour, judgment in the Nkandla hearing at the Constitutional Court has been reserved. Well, news organisations owned by the Gupta family file an urgent interdict against the EFF in the High Court of Pretoria. Still at home, the search for the 3 missing Lily Gold Mine staff members